Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law. And today I want to talk to you about something a little unique. And I just have it titled, Why is Joseph P. Kennedy named in my trust? So occasionally a person who has completed an estate plan with their lawyer may be surprised to discover a reference to Joseph P. Kennedy and his descendants buried deep within the trust document. Discovering in your very own personal estate planning documents the name of someone whom your family has absolutely no connection can be particularly puzzling and even distressing. Undoubtedly, such a circumstance has led to concerned phone calls to the drafting attorney demanding to know what on earth this is or what it even means. And it all has to do with this thing that we all learned in law school called the rule against perpetuities. The rule against perpetuities, also called RAP in our world, is a common trust provision often referred to as a savings clause. And it comes from a somewhat arcane rule that originated centuries ago in English trust law to prevent land-owning nobility from locking up their family wealth in trusts that could exist forever. A perpetuity has no end date. The RAP grew out of a case law and eventually became part of the statutory law in most states in some form or another. Traditionally, a common form of the rule was no interest is good unless it must vest, if at all, no later than 21 years after some life and being at the creation of the trust. And although it may seem simple on the surface, the rule's application can be fairly complicated and has resulted in plenty of controversy. One legal scholar even referred to it as a technically written legal nightmare and a dangerous instrumentality in the hands of most members of the bar. Now, a major problem with RAP was that traditionally courts could completely invalidate a trust document that violated the rule, leaving default state laws or intestate statutes to determine the terms for passing property to the deceased owner's heirs. Now, although many states have modified the rule to avoid invalidating the entire trust, it could still prevent certain beneficiaries from ultimately receiving their interest in the trust, frustrating the trust maker's intent for sure. The RAP, therefore, could have disastrous consequences for some families. Thus, it became critical to carefully draft trusts to avoid violating the RAP. So then we all came up with drafting language to get around the rule. As creating trusts became common for individuals and families, estate planning attorneys routinely used certain boilerplate or standard legal language in trust documents to circumvent the pitfalls that the RAP introduced. By naming an easily identifiable family with a large number of descendants, even if they likely have no relation or connection with the individual creating the trust attorneys use the RAP's language to designate the some life and being element of the rule, instead of using a life that was being related to the trust maker. The nature of Joseph P. Kennedy's family, with their well-known tendencies to have many children, made them a natural choice for a group of descendants from which the courts could identify some life and being to which the RAP could apply. By doing this, the argument goes, there was a much greater chance of identifying a very young life and being at the time of the interest creation, thereby maximizing the amount of time that an interest in the trust could vest in the trust named beneficiaries. Now, some attorneys have used other easily identifiable groups of descendants, such as those of Queen Victoria of England, the Rockefeller family of New York, and Brigham Young of Vermont, whose progeny is particularly extensive. But that being said, in many states, the RAP is becoming less of a concern when drafting trust. For example, Alaska has completely abolished the rule altogether, as well as Colorado and Utah have amended it to change from a period of time to 21 years to 1,000 years, minimizing the RAP's impact in modern estate planning appears to be a growing trend, and eventually the rule may have no real-world impact in the United States at all. Nevertheless, because there remains a wide variety of approaches to this rule from state to state, trust documents continue to include wrap savings language to ensure that the trust or an interest in the trust does not become invalid because the trust maker or beneficiary relocates to a different state. Even though wrap is becoming less relevant today in many states, it is still important to understand why your trust documents contain certain language. Americans continue to be very mobile, often living in multiple states over their lifetimes. Including carefully crafted language, such as the wrap savings clause in your trust, could have a real impact on your ability to craft a trust that accomplishes your estate planning goals and keeps your wealth in the hands of your descendants and your beneficiaries. While these arcane rules can be confusing at times, more often than not, they exist for a specific purpose and continue to have significant real-life consequences. By working with an experienced estate planning attorney, you can ensure that your goals are met and not frustrated by surprising rules such as wrap. If you have any additional questions about the wrap or other provisions in your trust, please feel free to give us a call or send out an email, info@kellylongtinlaw.com. You can always rely on our experience to help you and your family reach your estate planning goals. So I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families. If you found this beneficial, please like and subscribe to our channel.